what happens in this scenario? We call this foreign objects. Let's say you go in to have a surgical procedure done, and lo and behold, a couple of years later, you learn that a doctor left a clamp inside of you, a surgical clamp, or a lap sponge, or something that was never intended to remain inside of you. These are foreign objects. I don't mean aliens, but I mean something that should not be inside of you. How much time does the injured patient have to bring a lawsuit at that point? Anybody know?
2.5 years from either discovery of the device or when you should have known.
Close. And that's going to apply to a failure to diagnose cancer case, which is brand new this year. But let me get back to this because that's close. Okay? We have a date of discovery rule, which is what you were referring to. So in New York, you have 1 year from the date of discovering this foreign object in which to bring a lawsuit, or, pay attention to this, when you reasonably should have known that this object existed in you. That little addition makes a huge difference, and I'll tell you why in a minute. Okay, so you've got 1 year from the date of discovering it. But before you can know for sure whether or not this person's case involving a foreign object is timely, we have to ask one other question. And the one question we have to ask is, was this device, this thing that was inside of you that was found, was this something that was intended to remain inside of you? Or was this something that never, ever should have been left inside? Very important, and I'm going to give you an example which should illustrate exactly what I'm talking about. So this young couple, they're in their late 20s, recently married, have been trying to get pregnant for a while. They can't. So they decide to go for fertility testing. And it turns out that the wife, everything's working with the wife. The husband is the problem. What's the problem? The tube that takes the sperm from the testicles up and out has been closed off. And the doctors who are evaluating him asked him, have you ever had surgery before? He said, yeah, when I was a kid, like 7 or 8 years old, I had surgery because my testicle twisted. It's called a testicular torsion. And I had to have surgery to untwist it. And to make sure it didn't happen again, the doctor had to put a stitch in to make sure it was tied up against my scrotum. He said, that's the problem. The problem was that the doctor who put that stitch in didn't simply attach it to the scrotum, which is where it would have been fine, but he closed off that tube that allows the sperm to go from the testicle up and out. Okay, so now he decides to bring a lawsuit against the doctor or the doctor's estate. It's been a long time. It's been, since he was 7. He's now 27, 28. And now the defense turns around and says, listen, we're sorry for what happened, but you're untimely. So let's answer the question. Let's ask the question first. Was this thing that was left inside of him something that was intended to remain inside, or was this something that never, ever should have been left in? It's a stitch that was put in to hold something to another piece of an organ, right? That was intended, which means that if he were an adult, and he wasn't, but he was a child, but for the moment, if he were an adult, he would have 2.5 years from the date of the malpractice in which to bring a lawsuit. That's different than the date of discovery. And unfortunately for him, he was way past the age of majority, which is when it normally would have been extended to as a child. And it was many years beyond that. So the court says, sorry, your case is not timely, and they dismiss the case. But let me share with you another scenario where this device, or something left inside, turned out to have the opposite effect. And before I get to that, I want to address the thing that you mentioned earlier. So in January of this year, the legislature finally, after decades of lobbying, they finally changed the time limit to bring a lawsuit for patients involved in claims of failure to diagnose cancer. In a failure to diagnose cancer case, typically you have 2.5 years from the date of the malpractice to bring a lawsuit against a private doctor in a private hospital. And if it's municipal, you know what the time is, right? 90 days from the date of the wrongdoing, and 1 year and 90 days to file your lawsuit. Okay. There was a woman named Laverne Wilkinson. Laverne died as a result of improperly diagnosed cancer at a municipal hospital. Her family decided to bring a lawsuit, or tried to bring a lawsuit against the municipal hospital, but had no luck because they were way beyond the time limit. So on her family's behalf, there was a great deal of lobbying designed to try and change the inequity associated with the fact that many patients and many families don't realize until way later that somebody now has advanced cancer and they should have picked it up much earlier. And if they had, none of this would be occurring. So now we have a date of discovery rule, which says that if you have cancer and you believe your doctor or hospital staff failed to timely recognize it, guess what? Now, you have 2.5 years from the date of discovering it within which to bring a lawsuit against a private doctor or private hospital. But that only extends for 7 years from the date of the wrongdoing. Okay, so the law allows us some leeway, saying, hey, the maximum cutoff time is 7 years. So now what happens in a municipal hospital where there's a failure to diagnose? Do you still get the benefit of that discovery rule? The answer now is yes, which is a great thing, but we all know what the time frame is for municipalities. You still, from the date of discovery, you have only 90 days from the date of discovering it or when you reasonably should have recognized it. And then you have 1 year and 90 days to file suit. So that helps benefit these injured patients because of only failure to diagnose cancer cases.